Hello, hi Tanya. Hello, Pratika is here. Okay, can I just get a few comments from who else is here? All right, Prachi is also here. So, a very good evening, guys. I hope you're doing well. Your educator today, Gagandeep, was unavailable due to some technical issues, and I will be taking up your SRA quiz next for today. And I hope you're doing well, and I hope you've taken part in your mock test today. Do let me know if you have and how it went. Since it was Sunday, maybe the queries might have taken a little bit longer than usual to resolve, but you can let me know here. And if not, please make sure you're attempting your quizzes 24 hours later. So if it did go live from 2 in the noon today, 2 in the afternoon, it will be made re-available from 2 p.m. tomorrow. So make sure anything you're missing, you're re-attempting and taking the time out to attempt the following day. And also make sure no papers are left unattended in your mock test series. You must attempt every single paper. And also, I hope you're taking the marathons. So I think we're ready to begin the quiz. Just let me know if we all good to go. We have Prachi, Pritika, and Tanya speaking uh, and commenting so far, and no one else. Okay, Tanya is ready. Excellent. Tanya, Pritika, have you taken the exam, the mock test paper today? Okay, jolly. Shaktija is also here. Shaktija, I looked into the attempt issue and we were discussing it all day yesterday. Good evening. And don't worry, it will be resolved. We were able to see your scores and your attempts, and it was all there. So we are resolving it, and your name will be reflected in the reports. The reports will be sent again. Okay, Tanya says she'll give the mock after the quiz. But Tanya, please make sure you're submitting it well in time. Don't wait till 11 because then you only have 59 minutes to submit it. Because if you start submitting it at 12 exact midnight, it won't really submit. So, with that, let's begin our SRA quiz. SRA, very important subject from the perspective of not just DJs, but being a judge and being a prospective judicial officer anywhere. Something that doesn't really catch our eye, but has widespread application, but has a very is of a lot of gravity when it comes to applied law, and you must be well versed in it. We all know the basics behind the Specific Relief Act and why it functions and why it exists and how it operates. So we understand that, and with that understanding we know uh, how practical it is and how necessary it is for daily functioning of modern society, so and in dispensing justice everywhere. So the Specific Relief Act, as we know, stems from, we have a lot of contractual obligations, and we have a lot of dispensing of justice critically to do, and the specific relief act comes in clutch to make sure that we are doing it, so that it opens up newer ways, it opens up, abnormal ways for us to dispense justice, which we otherwise could not have encountered before in specific legislations. So let's start a quiz, a quick round of understanding the specific relief act. As always, I expect all of us here to beat the timer, to have answers ready before the timer even begins. So here we go. Our first question is, the Specific Relief Amendment Act 2018 received presidential assent on 17th September 2018, 5th June 2018, 1st August 2018, or 4th June 2018. Let's have the answers. Come on, guys. Prachi thinks it's 1st of August 2018 that it received the assent. Anyone else? And Prachi is absolutely correct. Tanya, no, not the fourth option. It was 2018, August 1st, that it received the presidential assent. We have our next question. The Specific Relief Act is an act to do which of the following? Is it an act to consolidate and amend the law relating to certain kinds of specific relief? Or B, is it an act to define and amend certain parts of the law relating to contracts? Or C, is it an act to define and amend the law relating to certain kinds of specific relief? Or D, is it an act to define and amend the law relating to certain kinds of specific relief and contracts? Be very careful about what the options state. 1 and C are not quite the same. So what could be the correct option here? Consolidation amendment of law relating to kinds of specific relief, definition and amendment of certain parts of contract, or definition and amendment of law relating to specific relief. Most of us here think it is the definition and amendment of laws relating to specific relief, apart from Nikunj, who thinks that it is to consolidate and amend the law relating to specific relief. So again, understanding the significances of all the terms, understanding the significance of consolidate and amend, understanding the significance of define and amend. It is not consolidate and amend, it is define and amend. So Nikunj, you went wrong because you said consolidate. Consolidation happens to those acts which already, those laws which already exist in fragments, in tiny fragments, and then you consolidate them. You bring all of that together. But with respect to specific relief, there was no tiny fragments around of it. So we cannot really state that the SRA Act is consolidating anything. It is just defining what specific relief can be, and it also, of course, amends the law relating to it. Next question. Who defined the law of specific relief as a part of the law of procedure where the suitor gets relief in specie? So who made this definition? Was it A, Sir Frederick Pollock? Was it B, Lord Denning? Was it C, Justice Benjamin Cardozo? Or was it D, Sir William Anson? So very familiar names for us from jurisprudence. Of course, what do we think? Can we have the guesses come in? Who made this definition, this famous definition of the Specific Relief Act? Come on, guys. Shaktija thinks it's Frederick Pollock. Someone else. Ritika Prachi also think it's Pollock. That's correct. He has made this definition and emphasized that it is a form of judicial redress. The suitor is getting relief in specie. That means the very thing which the other party was bound to perform or to forbear in specie, the exact thing that the suitor wanted is being dealt with. Okay, so the unique nature of specific relief is such that he gets a very specific relief, the exact thing which he sought to get. It's a very specific remedy, it's not general in nature. Next question. What are the essentials for a suit by person dispossessed of immovable property? So what needs to exist in a suit where a person is dispossessed of immovable property? That specific suit, what does it need to have? So in this case, do we require that a person has been dispossessed from immovable property? Is this one of the requirements? Or B, is it that his dispossession is such that it has been done without his consent? Or is it that his dispossession is such that it is done without due process of law? Or is it all of the above? We have 3 answers for D, all of the above. I have started the timer just now. Come on, guys. Very obvious the answer here, and it is correct. We see Section 6 of the SRA highlight what are the essentials of suits where a person has been dispossessed of their immovable property, removed the immovable property has been removed from their possession, and wherein what we require for that suit to persist and legally exist is that the person has been dispossessed in such a manner that it is without his consent. First of all, we need to establish that he has indeed been dispossessed. The dispossession is without his consent, outside of his consent, and it is also without due process of law. It can be with due process of law and without his consent, because if someone is removed from a property that is not rightfully theirs, it of course is without their consent. They don't want to move out, but it is with due process of law. So those suits will not persist under SRA. If we want SRA specific relief for these cases where the dispossession has happened, it needs to exist, first of all, the dispossession in essence, then it needs to happen without the consent of the person dispossessed, and also it needs to be without due process of law, because if it is with due process of law, it is legitimate. Next question. In the absence of filing a suit within the prescribed time under Section 6, so the very thing we were dealing with, what is the solitary recourse available to the aggrieved party? So, in the absence of filing a suit within the prescribed time, so if you're exceeding the time, what is the solitary recourse? What can you rely on finally? Is it that you get monetary compensation for dispossession? Is it that you get injunctive relief against future dispossession? Is it that there is a window for submission of a fresh suit with an extended time limit? Or is it that you can have a title established through a more robust process under Section 5 instead? Which of the following is the correct answer, guys? Guesses? Come on. So, monetary, future injunctions, a more robust process, or you will be allowed to submit a fresh suit. So, we think it's establishing a more robust process under Section 5, which is correct. So, if under 6 you fail to prescribe to the given time limit, the only relief is provided in a more comprehensive manner, and you resort back to what is provided in section number 5 of SRA. Next question, again going along the same thread, Section 5. What is the primary focus of Section 5 in the context of immovable property? What does it do? Does it establish time limit for filing suits? Does it outline the procedural intricacies of the Specific Relief Act? Does it allow for detailing remedies and provide them to people facing dispossessions? Or does it define the legal requirements for transfer of property? So, what is the primary focus of Section 5, guys? Your timer has begun. Let's have answers come in. So we need to understand Section 5 completely to answer this question, the primary focus of Section 5. I've not had any guesses so far. Come on, guys. Shaktija, Prachi thinks it's B. More guesses? And it is C. It deals with explaining the various legal remedies. So if a person has already been dispossessed, it, like we just saw, it expands the horizons of a person who has been dispossessed and otherwise is not following or falling under the procedure under Section 6, for example. So it just explains the various legal remedies. It expands their access to justice. That's what essentially Section 5 does. Next question. What conditions must be fulfilled for a person to file a suit for the recovery of possession? So, if you want to file a suit for recovering possession, what are the essentials that you must satisfy? 1. The person must possess the property and have government approval of such possession. Or B. The dispossession must be consensual and done with court permission. Or C. The person must be in possession of the property and the dispossession must be unlawful. Or D, there are no specific conditions outlined. So, what do we think the answer is? That you need to establish before the court that I was dispossessed and I want successful recovery of possession of this property. What do you need to satisfy? I will begin the timer now. Let's have guesses come in, guys. Let's have the guesses come in. Okay, we all think it's option C again. And that is correct. Again, by application of Section 6, a person who, without his consent and without due course of law being taken into account, is removed from the property, dispossessed of the property. He or any person through whom he has been in possession, or any person claiming through him that property, he may by suit recover its possession, notwithstanding any other title that may be set up in such suit. Next question. What is the precise time limit mentioned in section 6? The same thing, the same thread, we're following the same thread, the time limit of section 6 and recoursing back to section 5. Now, what is this time limit? Is it 3 months? Is it 6 months, 9 months, or is it 1 year? We must know this. What is the first time limit in section 6 for the suit of dispossession, recovery of possession? It is 6 months. Let's have the timer bigger. All right, Adivya, I think Tanya. I don't see Tanishka today. Section 6, yes, it explicitly mentions that 6 months from such dispossession is the time window where you must begin the process of your suit and institute the suit for recovery of possession. Now, against whom does Section 6 specifically bar the filing of a suit for recovery of possession? Who is devoid of the benefits under Section number 6 of SRA? Is it individuals as a category of people? Is it corporations? Is it the government? Or is it non-profit organizations? Again, a question we must not need to think a lot about. So let's have the guesses come in. Okay. I have begun the timer. 4 votes for option C, which is government. What do the rest of us think? Option C, government, is correct. The government itself cannot bring a suit under section number 6 of SRA. What is the primary subject of section number 7 of the Specific Relief Act and its subclauses? Again, we were trying to understand the focus behind section 5 before. Now we are moving on to the focus behind section 7 of SRA. Does it refer to recovery of possession of immovable property, or the procedure for recovering movable property, or does it deal with rights of a trustee in immovable property, or is it none of the above? We have Pritika answering recovery of possession in immovable property. Amar, Tanya, Tadivya voting for option B, that is procedure for recovering movable property. And the correct answer is B. Section 7 itself, it focuses on the procedure for recovering movable property, and the subclauses detail the rights of trustee, special rights, etc., which need to exist for filing a suit, the existence of special rights. Next question. What are the prerequisites for an individual to file a suit for the recovery of movable property? So, an individual wishing to file a suit for the recovery of movable property, what essentials does he need to suffice? A very procedural law, the SRA. So, you have to understand essentials, time frames, failures to satisfy time frames, and the recourse, the next legal recourse that is available. So, the essentials here are either the property must be immovable and have a special right attached to it, or the property must be movable, capable of being delivered and or dispossessed of, and the person must have possession, or is it that the person must be the owner of the property and have a beneficial interest, or is it that the person must have suffered actual damage to the property? So, bringing as an individual, bringing a suit for the recovery of movable property, what do you need to satisfy here? I have begun the timer. Let's see the guesses. Is it the existence of immovable property with a special right? Prachi thinks the property needs to be movable, capable of being delivered, and the answer is correct. Section 7 provides that it requires for this suit to be made by an individual, the property needs to be, there needs to be a movable property to begin with. It needs to be, capable of being delivered or dispossessed of, and the possession needs to be with the person who is instituting the suit. Next question. What conditions make a person eligible to file a suit for recovery of movable property? What conditions? Next, we dealt with recovery of an individual's movable property. Now we are dealing with what essentials are required for bringing a suit for recovery of movable property. The very important distinction here is understanding immovable and movable property and taking care of reading the questions correctly. Option 1, the person must have exclusive ownership of the property. Is this a condition that is required? Or that the person must possess the property? There should be a special right or temporary right attached to such property. Or is it that the person should be the property should be a trust property and the person must be a trustee? Or is it that the person should be entitled to compensation for wrongful possession? So, what conditions, the existence of which of the following will allow for a suit for recovery of movable property. And your time has begun. Prachi thinks it's option B. Anyone else? Shaktija thinks it's D. And it is indeed B. Section 7 again, going back to the drawing board. Section 7, it necessitates that the person filing the suit must have possession of movable property. There should be a special right or a temporary right, either of the two, along with the existence and possession of the movable property. So Shaktija, option number 2 was correct, not 7. Next question. In what circumstances can a person be compelled to deliver movable property to another person? So, a quiet return of events for specific relief act. When can one person be compelled to move movable property from his possession to another person? One, when the property is unique and has sentimental value for the other person. Two, when monetary compensation is considered adequate relief. Three, when the possession of the article has been wrongfully transferred from the rightful owner. Or D, when the article is held by the defendant as a trustee of the immediate possessor. So, which of the following can be the correct answer here? Can we have a few guesses? When the compulsion of delivering movable property to another person can be made? We think the correct answer is D. So, where the person is a trustee and needs to move it to the person whose trust he is holding it in. Okay, according to Section 8 of the Specific Relief Act, these are now the circumstances where this possession, delivery of possession can be made from one person to another. First, where the article is held by the defendant as a trustee of the person who has immediate possession, yes. Where compensation in money is not considered an adequate relief. So the answer number B was is considered an adequate relief, but the condition is that it is not considered an adequate relief. 3, when it is difficult to ascertain the actual damage caused to the person. Or 4, where the possession of the article has been wrongly transferred from the person entitled to it. So of course you need to make right that wrong in that situation, so that possession is reversed then. But our correct answer here was when the article is held by the defendant as a trustee of a person who has immediate possession. That is the correct answer in this particular question. According to Section 8, when is compensation in money considered inadequate for recovering possession of movable property? So there are instances where compensation in money may suffice. There are instances where compensation in money shall not suffice. Now, which of the following is an eventuality where the compensation in money is not sufficient? Is it when the property has sentimental value? Is it when it is difficult to ascertain actual damage caused to the person? Or is it when the property is easily replaceable? Or is it when the person in possession himself is the rightful owner? The timer has begun now. Let's have the answers. So when the property is easily replaceable, some people answering for that, or when it is difficult to ascertain, and option B, difficulty in ascertaining the actual damage, is the correct answer here. Dealt with under Section 8, that when compensation in money, when it shall be inadequate, it shall be inadequate when you cannot ascertain how much damage is caused to the person in possession of the movable property. Shaktija has corrected. Yeah, Shaktija, it is indeed B and not A. Next question. Under what circumstances, according to Section 10 of SRA, does the court generally exercise its discretion in enforcing specific performance of a contract? So, what circumstances allow, as per Section 10, for the court to exercise its discretion in enforcing specific performance of a contractual relation? Is it when damages are easily quantifiable? Is it when the breach involves immovable property? Is it when money is deemed an adequate relief itself? Or is it when the property is an ordinary article of commerce? So, when is the court generally exercising its discretions? I have begun the timer. Let's have guesses come in. What do we think? Come on, guys. Section 10. General application of Section 10. Amar has went for D. Prachi has answered right. So Section 10 states that by default, in these situations, in contractual obligations, and specifically having contractual obligations be relieved, a failure of contractual obligation. So specific relief will exist when a contractual obligation has failed from being realized, right? So having this reflected a contractual obligation, Section 10 states that here, when it is related, the breach of a contract is related to immovable property, the court just assumes that money is not an adequate remedy here, right? So, which is why, in absence of money fulfilling the void, you need to lean towards specific performance. In itself, it's very reflective. Let's look at the question. See, Section 10. When does court exercise discretion in enforcing specific performance of a contract? If the contract could have been performed, or if the relief could have been provided by money, why would they need specific performance, right? So they only need specific performance when money cannot fulfill the void, so to speak, right? It cannot adequately be made right or made correct by money. Next question: what condition, as per Section 10, makes specific performance of a contract more likely to be enforced by the court? So, what makes it more likely to be enforced by the court? One, the breach involves movable property, or that damages or loss due to non performance are easily ascertainable. Easily ascertainable. Bear in mind the terms. Or C, money compensation is considered adequate relief. Or D, the property is not an ordinary article of commerce. Again, on Section 10, what makes specific performance more likely to be enforceable by the court? And your timer has begun. Let's attempt some guesses. Amar again thinks it's option number B. And it's D, Section 10. We are leaning towards Section 10 again. It creates a presumption that the breach of a contract involving movable property cannot be adequately compensated by money unless the property is an ordinary article of commerce. Shaktija thinks it's A, Atidevya thinks it's D. Next question. Under what circumstances, as per the SRA, would a contract be considered not specifically enforceable? So, which contract will we are going towards contracts here, a specific use of the word contracts. So, where would a contract be considered not specifically enforceable? Is it where the performance of the contract requires or involves the performance of a continuous duty which the court cannot supervise and the court cannot keep tabs on it, so it's not, logically specifically enforceable? Or is it a contract which is so dependent on the personal qualifications of the parties that the court cannot enforce specific performance of its material terms? Again, it becomes an issue in technicality. Or is it a contract which is in its nature determinable? Or is it all of the above? I will begin the timer. Please make sure you're bringing in your guesses now. It is A. Section 14 states that only such contracts are not specifically enforceable where substituted performance in accordance with Section 20 of the Act has been obtained, or where the performance is of continuous duty which the courts cannot supervise. This was option A. Or where the contract is dependent on personal qualifications that the court cannot enforce it on its material terms, or where the contract is determinable. Next question. To which geographical extent does the Specific Relief Act 1963 apply? So, what is its extent of application? Is it whole of India except the state of J&K? Is it the whole of India? Is it only to capital cities of the state? Is it the whole of India except the Union Territories of India? Again, a question we must not need a lot of thinking for. Prachi thinks it's whole of India, and that is correct, specified in Section 1 of the Act. Now, some case laws here. No, yeah, B. I thought someone answered D. Yes, guys. Some case laws here. In the context of Geeta Rani Paul versus Dibyendu Kundu, what is the primary requirement for a plaintiff filing a suit regarding dispossession? So, what was highlighted as a primary requirement in the case of Geeta Rani versus D. Kundu? Was it that there needs to be proof of being divested from the property on part of the person filing the suit? Or does it that there needs to be a proof of title over the property in the first place? You need to prove that there is a title that you hold on the property. Or is it that there needs to be a proof of contract performance? Or do we need a proof of damages that have been incurred as a result of such dispossession? I will begin the timer now. Again, a case specific answer that you have to provide. What was highlighted as a concomitant? Amar thinks that it needs to be that there was divesting from the property, and it is B. You need to prove title over the property as a person. You can only, you can only approach the court when you have a title in yourself. In this case, the Supreme Court ruled that if you're a plaintiff filing a suit about dispossession, you have to just prove what is manifest. Only if you prove that you yourself have a title over the property, that will entitle you to sustain the case. Other details, again, the question was which of these is key, which of these needs to be there in order to sustain the suit. Other details like whether you were divested, whether you were whatever, whether you suffered damages, that happens later on. But if you fail to prove that you have a title at the outright stages, you cannot maintain the case. That is what was meant by the question. Next question on cases, according to NP Thirunagram versus Dr. R.J. Mohan Rao, under what circumstances might a court decide in favor of the defendant in a specific performance case? So the case is going in favor of the defendant here. Why? Is it because the plaintiff has not performed his portion of the contract? Is it because the plaintiff wants to perform but he is facing certain hindrances? Is it because the defendant himself has failed to perform? Or is it that the contract in itself was voidable in nature? Can we see some guesses? I think a few students are answering in favor of A. All right. We are receiving a few answers. Aditya has gone also for A, and A is correct. The court stated that if the plaintiff himself is not fulfilling his obligations per the contract or he has no intention to perform them, the case goes in favor of the defendant naturally, as it tends to. Next, case law here, case law in focus here is Prem Singh versus Birbal. Under what circumstances per this case does the question of cancelling a contract arise? So, where does cancellation of a contract come in? Is it where the contract is valid? Is it where the contract is void ab initio? Is it where the contract is voidable in nature? Or is it when the contract is not in the interest of the plaintiff himself? So the case of Prem Singh versus Birbal, and the question of whether we can cancel a contract itself. This is SRA. So within SRA, can we cancel the contract, its obligations, because of something we uncovered? Prachi thinks it is the contract is void ab initio, and that is correct. So if the court held that if a contract is void ab initio, the question of cancelling it, obviously it does not arise because it is obviously cancelled at the SRA stage. At the specific relief, at granting the specific relief, you uncover something that tells you that the contract is void ab initio. Of course, it has no legal standing. The entire contract can be discarded. It is automatically cancelled. Next question. Which contract is not specifically enforceable? Is it a contract where a party to the contract has obtained substituted performance of contract? Is it a contract where the performance of the contract involves the performance of a continuous duty, which the court cannot supervise? Is it a contract which is in its nature determinable, or is it all of the above? Again, a question we must all know the answer to. D, all of the above. Any more guesses? D, and that is correct. Section 14 tells us that all of these contracts and more where the contracts cannot be specifically enforced under the SRA. Next question. As a general rule, the court shall not direct the specific performance of part of a contract, but under which section of the SRA is the exception to this rule given? So the general rule is that the court does not direct the specific performance of parts of a contract, but where can such specific performance be given? Under which section? Is it section 11, 12, 13, or section 14? Shaktija thinks it's 14. Pritika thinks it's 12. 12. Prachi thinks it's 12 as well. And that is correct, because under sections 12 subsection 2, 3, 4, we have circumstances where the court can go to the extent of having specific performance done of parts of contracts as well. Next question. The provision related to power of court to engage experts. So we see the engagement of experts in evidence and other laws, but under SRA, which amendment act added the power of the court to engage experts? Was it done by the 2000 Amendment Act, the 2005 Amendment Act, the 2013 Amendment Act, or the 2018 Amendment Act? I've begun the timer. A very key change made in the SRA, the power to engage experts. All right, we think 2018, and that is correct. And where is it done? Under section 14A of the SRA. It gives the court power to engage experts. Next question. A party can seek the specific performance of a contract. What contract? Written agreements, oral agreements. Can it be both A and B? Or it's supposed to say none of the above. Sorry, guys. It must be none of the above. It has to be both A and B or neither A and B. Okay, Shaktija thinks it's only written agreements and not oral agreements. Tanya thinks it's only written agreements, not oral agreements. Any other guesses? And it can be sought between both. It is D, both oral and written agreements. You can have specific performances because they're both contracts, as we know. Next question. According to Bentham's idea, what is the primary objective of the law of specific relief? So we saw what Pollock had to say about SRA, but what, according to Bentham, does the SRA have to provide? Does it provide for equivalence for every legal claim? Is it there to assure individuals everything that rightfully belongs to them without mandating acceptance of equivalence? Is it there to enforce specific performances and damages equally? Or is it there to prioritize money compensation over actual possession? Bentham's idea of the SRA. Which one of these is it? So Aditya thinks it's B. Any more guesses here? Aditya is correct. Bentham has expressed that the law of specific relief, it gives individuals what they rightfully deserve, what rightfully belongs to them, without being compelled to accept substitutes or equivalents, because we saw that it is a law which gives you in specie what you require, the exact thing you have wanted. It is very specific. It does not give you a general thing, or it does not give you the next best thing. It does not give you the monetary compensation. It gives you exactly what you were looking for. How does Bentham's perspective as influence the approach of the law of specific relief? What does Bentham's perspective of SRA reflect? Does it advocate for a system of strict equivalent for legal claims? Or does it emphasize the acceptance of substitutes as a primary remedy? Does it promote the prioritization of specific performance over damages? Or does it assert that individuals should accept equivalence for the sake of legal efficiency? The answer to this is very obvious in light of the explanation I just provided. So, what is the correct answer here? What is the effect of Bentham's ideology and perspective of the SRA? That is right. It is C, that we must not take the second best thing, like I said. You should take what is rightfully yours, the specific performance. No priority, no compromising with the priority. If you want specific relief is what you shall get. Under the Specific Relief Act, a suit for recovery of possession can be filed in which of the following: only in respect of movable property, only in respect of immovable property, in respect of both movable and immovable property, or is it neither for movable nor for immovable property? Where can the suits be filed? For which of these? In respect of both movable and immovable property. That is correct, because we see cases where we have to deal with movable property and immovable property. You can be dispossessed or divested from both of these. Now, the SRA, what is behind the inception of the SRA? What is it a product of? Is it a product of the 8th report of the Law Commission of India on the SRA? Is it a report of the 9th report of the Law Commission of India of SRA, or the 10th report, or is it something else and thus none of the above? Let's have answers. B, that is correct. Why? Because the earlier act was repealed and substituted because of the suggestion of the Ninth Law Commission report of 1958. That is what led to the current act. So the Ninth Law Commission's reflections are why we have the SRA presently. Which section of the SRA provides that the specific relief to be granted only for enforcing civil rights and not for enforcing penal law? So, which specific provision mandates that the SRA is here for enforcing civil rights and not for enforcing penal laws? So, civil entitlements. Section 2, is it section 3, section 4, or is it section number 5? C, section 4. I think Shaktija thought it was section 3. Any other guesses? That is correct. It is section 4. Yes, Shaktija, it is section 4 indeed. What does section 9 of the SRA provide for? We must know this. Is it reflective of the ground on which SRA specific performance of the contracts can be granted? Is it the defenses which a person must engage against whom the relief of specific performance is claimed? Is it the defenses which a person against whom the specific relief of specific performance is claimed cannot plead? So the opposite of option B. Or is it the grounds on which specific relief of a performance cannot be granted? So what does it deal with? Can be granted, cannot be granted, can be claimed, cannot be claimed. Prachi thinks it's B, the defenses that can be engaged and can be pled. It is defenses respecting suits for relief based on contracts. So it is an exception, except as otherwise provided, where any relief is claimed under this chapter in respect of a contract. The person against whom the relief is claimed may plead by way of defense any ground which is available to him under any law relating to contracts. So that, I think, makes option B, the ability to claim, correct, and not C. That's right. Now, next question. After the 2018 Amendment Act, what is the status of Section 10 concerning courts enforcing specific performance of contracts? After the 2018, what is the status of providing specific performance? Is it a mandatory requirement? Is it a discretionary requirement? Or is it something that has been deemed to be prohibited? You're stopped from doing it. Or is the status of it ambiguous still? Do we not know what it is? So, okay, Shaktija and rest of us here think it is discretionary. Prachi thinks it's mandatory. Anyone else? What is the nature? We must remember that the 2018 amendment it marked a watershed moment in the nature of specific relief, especially for contracts. Specifically for contracts, it made sure that the words may were replaced with shall. That means it is no longer an option to make specific performance of contracts. The courts are obligated to make sure that performance of contracts is done. That means the enforcement of specific performance of contracts as a relief to the person approaching the court is not discretionary, it is now mandatory. This is very, very important. We should not be getting this wrong, Shaktija, Pritika. This is very important. Let's bear this in mind. It is now mandatory. Earlier, it was discretionary because it said may. So the court may decide on its own, but now the word shall reflect that it is mandatory. The statement specific performance is the rule, monetary conception is the exception, signifies a shift in favor of awarding monetary compensation over specific performance, a shift towards making specific performance the preferred remedy over monetary relief, an equal emphasis on both, or a restriction on the availability of both specific performance and monetary compensation. What is the statement reflective of? Again, specific performance is the rule, monetary compensation is the exception. So what do we see it go in favor of? That is correct. B. It suggests that there has been a change in approach again with the Amendment Act of 2018, a very landslide change in the SRA. Specific performance is now the norm, as we saw by the substitution of words shall against may, and monetary compensation is the exception. So, what is preferred is getting again exactly what you wanted for, and not monetary compensation as the next best thing. Now, which section deals with definitions for interpretation of terms? Is it section 1, 2, 3, or 4? Again, a very quick question. Definitions for interpretation of terms. Section 2, as always, yes, with definitions here. What is the primary focus of the SRA in contrast to the Indian Contract Act? So, comparatively, what do we see as a focus of the SRA? Is it providing compensation for all breaches of contract? Is it regulating contracts in India? Is it introducing the concept of specific performance as a remedy? Or is it the act of repealing the Indian Contract Act? Let's have the answers. Let's not wait for the timer. Very obvious answers for some questions. We need to establish mental agility with these quizzes. Okay. Establishing specific relief and specific performance, and that is correct. It focuses on introducing the concept of specific performance as a remedy, which goes beyond the scope of Contract Act. Erstwhile, the Contract Act was not allowing for this, it was not providing for this. So that is exactly what that steps in to do. Now, when was the act adopted? Sorry, why was the act adopted, the SRA Act adopted? Was it to regulate contractual obligations? Was it to provide relief for compensation in case of breach of contracts? Was it again to introduce the concept of specific performance as a breach, as a remedy for breach of breach of promises or contracts? Or was it to repeal the Indian Contract Act? Again, very obvious what the SRA does and why the need of it was felt. Again, to provide an alternate, focused approach towards the obligations in contract. There needs to be something that obligates people towards fulfilling their contractual obligations. As a general rule, the court shall not direct the specific performance of a part of contract, but under which section is the exception given? This seems to be repeated, but let's see earlier. Let's see how many of us get it right now because it was repeated before. Yes, guys. Section 12 says Adivya Pritika. Section 12. And that is correct. 12, 2, 3, and 4, as we discussed before. Now, the enforcement of a contract through specific relief can be achieved by which of the following means? Can it be achieved by beneficiary of a contract relating to settlement on marriage or a compromise of doubtful rights between members of the same family? Is this the nature of contract that is taken up in specific relief? Or is it where the representative in interest brings it or the principal of any party brings it? Are these the people involved? Or can any party bring the contract? Or is it all of the above? So, which actors in a contract can bring contracts to the ambit of SRA? It is D. So, section 15, it tells us how you can achieve specific performance and who is entitled to seek specific performance. It can be any party to the contract, yes, of course, but also the other options too, right? So, Atidivya, the other options also were correct. So, it was people who were beneficiaries, the remaindermen, revisioners, right? Even companies for pre incorporation contracts. It even goes to the extent of allowing them to seek addressal. Next, the court, when assessing compensation under Section 21 of the SRA, should follow the principles that are outlined in which of the following? The court assessing compensation under Section 21. The principles for this are in 73 of the Contract Act, Section 75 of the Contract Act, Section 74 of the Contract Act, or Section 34 of the Contract Act. Of the Specific Relief Act, sorry. Principles that the court has to observe. Prachi, Tanika, Titivya think it's 73 of the Contract Act, and that is correct. That provides the principles that the court has to observe. Section 21(4) of the SRA states that when the court is assessing compensation, the principles of Section 73 of the Contract Act need to be borne in mind. As per Section 2, all other words and expressions used hidden but not defined, that means under the Act, and defined in the blank have the meanings respectively assigned to them in that Act. What does blank refer to? Is it the Contract Act 1872? Is it TPA? Or is it the Evidence Act? Or is it none of the above? So, what act is closely tied with SRA? That is correct. As per Section 2E, all words and expressions used herein but not defined and defined in the Indian Contract Act have the meanings respectively assigned to them in the Contract Act itself. Now, how many parts are there in SRA 1963? Is there only one part to it? Are there two parts to it, three parts to it, or four parts to it? ژور کٔڑمٕژ پٮ۪ٹھِمٕژ. No, that is correct. 3 parts to the SRA. Now, how many chapters are there in Specific Relief Act 1963? We dealt with parts, now we are dealing with chapters. Are there 7, 8, 9, or 10? Okay, that is correct. 8 chapters. Tanya, I think, answered 9, but it's 8. Now, sections. How many sections are there in the Specific Relief Act? 44, 45, 46, or 47? 44, 45, 46, or 47? And that is correct, 44 sections. Now, what is an instrument whereby the destination or devolution of successive interests in immovable or movable property is dispossessed of or is agreed to be dispossessed of called? So, what kind of instrument allows for this? Is it a will? Is it a testament? Is the instrument called a settlement? Or is such an instrument called a deed? An instrument, the destination, devolution of successive interest, whether in movable or immovable property, is agreed to be disposed of or is disposed of right there. Okay, we think it's a settlement for some students, and that is correct. That is how the Specific Relief Act defines settlement in Section 2B. That is effectively what the instrument of a settlement does. Now, according to Section 11 of the SRA, a contract that is made by a trustee in excess of his powers or in a breach of trust is which of the following? Is it specifically enforceable at the instance of the same trustee? Is it specifically enforceable at the instance of the second party? Is it specifically enforceable either at the instance of the second party or at the instance of the trustee? Or is it not specifically enforceable at all? What is the nature of such contracts? Tanya and Prachi think it's not enforceable, and that is correct. Why? Because Section 11 provides that a contract that is made by a trustee exceeding his powers will not be specifically enforceable. Now, next question. According to subclause 2 of 27 of the SRA, which of the following is not a valid ground for the court to refuse to rescind the contract? We know that the court can rescind contracts under the SRA. Now, where can the court not, which is not a valid ground to refuse to rescind the contract? Where does the court have to rescind the contract? Is it where the plaintiffs express or implied ratification of the contract exists? Is it where the contract is voidable or terminable at the instance of the plaintiff? Is it where only a part of the contract is sought to be rescinded and such part is such that it cannot be severed from the majority in the remainder of the contract? Or is it that the third parties, during the subsistence of the contract, acquired rights in good faith without notice and acquired them for value? Where can the court not refuse to rescind the contract? The court is empowered to refuse to rescind the contract, but where does this power stop? Okay, we think it's option number B. And that is correct. Section 27(2). With option B, the plaintiff has either expressly or impliedly ratified. Yeah, if only a specific part of the contract is sought to be rescinded and such part cannot be removed, it cannot be taken away from the rest of the contract. Next question. The dismissal of a suit for specific performance of a contract shall preclude the plaintiff from suing for. If the suit itself is dismissed, what is the state of the plaintiff? The plaintiff is precluded from suing for which of the following? For rescission of the contract, for injunctions, for compensation, or is it for cancellation of the contract itself? Come on, guys, let's have some yeses come in. The correct answer is we go to section 24 for this. The dismissal of a suit for specific performance of a contract or part thereof shall bar the plaintiff. So the plaintiff is stopped from suing for compensation of breach of contract, right? But he is not barred to sue for any other relief. But for compensation for breach of contract, that right stops and is limited right there. What consequence does 23, section 23 of the SRA stipulate when the party suffering breach opts for substituted performance through a third party or by their own agency? So if the party approaching the court is doing any of these, either opting for substituted performance by a third party or by their own agency, what happens per section 23 of the specific relief act? Does it happen that the right to claim performance happens against the party in breach? It operates against the party in breach, or is it that the entitlement to recover doubles the expenses and the cost incurred, or does he now have the option to cancel the contract, or does a forfeiture of the right to claim specific performance against the party in breach happen? Divya thinks it is forfeiture of the right to claim specific performance because he has now opted outside of the normal realm of possibilities. And that is correct. Section 23 says that if the party that is suffering opts for substituted performance outside of this, they forfeit their right to specific performance against the party in breach because they're already seeking other recourses. So they cannot, have their cake and eat it too. Now, under Section 22 of the SRA, what condition must be fulfilled before undertaking substituted performance? Important question. What must be fulfilled? Is it that the party suffering the breach must file a lawsuit immediately? Is it that the party suffering the breach must serve a notice of not less than 30 days to the other party? Is it that the party suffering the breach must obtain court's permission? Or is it that the party suffering the breach must first attempt self-performance before having recourse to the SRA? Pratika thinks it is notice of not less than 30 days. Let's have others' guesses. All right. And that is correct. 20 subsection 2 mandates the serving of notice of not less than 30 days to the other party to allow them to make the performance of the terms of contract. How a person entitled to the possession of specific movable property may recover possession. Now, what particular provision governs this? What particular legislation governs this? A person who is entitled to possession of specific movable property. Is it under SRA? Is it under CPC? Is it under contracts? Or is it under SRA as well as under CPC? Divya and Tanya think it's under both SRA and CPC. Pritika thinks only SRA. Prachi thinks only CPC. And so Section 5 of the SRA states that the recovery of specific immovable property by entitled owners happens per the procedures of CPC itself. So the correct answer for this is CPC, the recovery of specific immovable property. Again, this is Section 5 of the SRA. Which injunction may be granted to prevent the breach of an obligation existing in favor of a person, whether expressly or by implication? Which kind of injunction is it that is granted to prevent the breach of an obligation? Is it temporary injunction, mandatory injunction, ad interim injunction, or a perpetual kind of injunction? It is perpetual injunction, that is correct, because that is what will stop such an event. Okay, so in light of these statements, let's choose the correct options later. A, an injunction cannot be granted when the plaintiff has a personal interest in the matter. B, a suit by a co-parsoner against a karta of the family restraining from the house property of the joint family for legal necessity is not tenable. Now, is A correct and B incorrect? Is A an incorrect statement and B a correct statement? Are both correct or are both incorrect? You can take a while to read both statements again. And we can have a few answers come in as well. I think Shaktija believes that both are incorrect. Prachi thinks that A is incorrect and B is correct. Injunction cannot be granted when the plaintiff has a personal interest in the matter is incorrect. And Shaktija thinks that A is correct and B is incorrect. Let me have the timer. The rest of us can answer now. And it is C, both are correct. Next, perpetual injunction can be granted by a decree only upon merits of the suit. Temporary injunction may be granted after the judgment also. So statement A is telling us perpetual injunction can be granted by a decree only upon the merits of the suit, and option statement B is telling us that the temporary injunction may be granted even after the judgment is provided. Now, which of the following is right? Is A correct, B incorrect? Uh, is A correct, B incorrect? Is A incorrect and B correct? Are both right or are both wrong? Okay, we have answers coming in for this one. A correct and B incorrect, because we think temporary injunction cannot be granted after the judgment. And that is right. Your answers are right. Temporary injunction cannot be granted after the judgment. Specific relief, next question. A, absence of averment of readiness and willingness makes the suit for specific performance of contract liable to be dismissed. So the absence of readiness, right, or willingness makes the suit for specific performance of contract liable to be dismissed on part of the parties here. B, where granting injunction would cause delay in completion of project of electricity distribution, no injunction should be granted. Now, which of the following options is correct in light of these statements? A is telling us absence of averment of readiness and willingness. Atidevya thinks it is C, that is both are correct. And Prachi and Pritika think it is A being incorrect and B being correct. Shaktija thinks both are incorrect. Make sure you're reading the terms properly. Can, cannot, absence, presence, and B is incorrect and B is correct. It said absence of averment of readiness or willingness. Now, for what can an injunction be granted? Is it to prevent breach of obligation in favor of plaintiff, to restrain a person from instituting or prosecuting a criminal proceeding? Is it to prevent breach of contract, the performance of which would not be specifically enforced? Now, is it A, B only, both A and B, or in neither of the cases? There seem to be errors. I'll have your educator for today, Gagan, notified of the errors in the slides, but luckily we are catching up. So let's treat option A as A only, B as B only, C as both A and B, and D as neither A nor B. So for what can an injunction be granted? All right. And so an injunction can be granted in case of option A only, not in case of option B. Injunction can be granted where you prevent the breach of obligation to restrain a person from, just a moment. Yeah, to prevent a breach of obligation, right? Because you want obligations to be enforced. Temporary injunction is granted during pendency of a suit at the conclusion of the trial. Its granting is regulated by Specific Relief Act, or is none of the above correct? During pendency of the suit. So that is correct. So that's why we in the early answers answered that after the judgment, temporary injunction cannot be granted. Temporary injunction is an interim form of injunction that happens while the suit is ongoing, so that matters can just take a rest for a while until the final rights are determined. Which of the following is wrong? Injunction should not be granted to restrain a person from instituting criminal proceeding, to prevent breach in which plaintiff acquiesced, when plaintiff has no personal interest, when the property is situated outside the jurisdiction of all courts. So, which of the following is wrong? So, you have to pick one of these which will make the statement wrong, not one of these which will make the statement right. So, which of these is wrong? Again, make sure you're reading well. Injunction should not be granted. In which of these? I'll move on to the timer. Shaktija thinks it's when the property is situated outside the bounds of all the courts. In that case, injunction should not be granted. And that is an incorrect combination. But as per this, it's C. So when plaintiff has no personal interest, again, we'll have to check this. Let's move on to the next question, guys. Which of the following sections deals with personal bars? Now, personal bars to the remedy of specific relief. Personal bars. Which section enumerates the personal bars? Section 13, 14, 15, or 16? Personal bars to the remedy of specific relief. Section 16 deals with personal bars. That is correct. Which of the following is not regulated by SRA? Temporary injunctions, permanent injunctions, mandatory injunctions, or none of the above? Not under the ambit of SRA. Which of these? That is correct. Temporary injunctions. They're regulated by CPC itself. Section 37(1) states that they are such. They are to only continue in a specified time. Like I said, they're interim and they determine rights of parties only for a small pocket of time. And the final rights are not determined by it. And temporary injunctions are governed by CPC. Dismissal of a suit for specific performance of contract shall bar the plaintiff's right to sue for which of the following? Rescission of contract, injunction, compensation, or cancellation of a contract. Again, I believe this also existed before. So we should know the answer. And again, it bars his right to sue for compensation and not others. So he cannot sue for compensation after the dismissal of a suit. Next, a contract made by a trustee in excess of his powers or in breach of trust under Section 11 of SRA is. This also seems to be repeated. So, the answer to it was not specifically enforceable because he has exceeded the ambit of his rights. In a suit, preventive relief is granted in which of the following forms, right? Preventive relief. Which of these is synonymous with preventive relief? Is it temporary injunction? Is it perpetual injunction? Is it declaration of rights that makes preventive relief possible in a suit? Or is it all of the above, temporary, perpetual, and declaration of rights as well? So, which of the following is correct? Is all of the options. Okay, we think only A and B are correct. That means by temporary and perpetual and not by declaration of rights. And that is right. By perpetual and temporary injunction, not by declaration of rights, does this happen. Temporary injunctions are to continue until a specified time, or until the further orders of the court, or until the death of one of the plaintiffs, or until the death of one of the dependents. So all of the options correct. Is only the option for specified time correct? Are the options for death of one of the plaintiff or death of one of the dependents correct? Or is the option specified time or death of one of the dependents or for the order of the court correct? On the timer. The order or specific time is what Shaktija, Prachi, and Tanya think the correct answer is, and that is right. So, specific time is what temporary injunctions or until the further orders of the court. The court might as well remove it before the specific time period has elapsed. So, an injunction can be granted for which of the following purposes? To restrain any person from applying to any legislative body. Is that an objective behind injunctions? Or is it to prevent the breach of an obligation? Or is it to prevent a continuing breach in which the plaintiff has acquiesced? Or is it to prevent the breach of a contract of performance of which would not be specifically enforced? What is the purpose of injunctions? B, prevent the breach of an obligation. That is correct. That is the whole point behind injunctions. The function of mandatory injunctions is to do what? Is it granted when it is not necessary to compel the performance? Is it in a situation where any act is necessary to be performed? Is it where you want to prevent the breach of an obligation and it is necessary to compel certain acts for being performed, or none of the above correct? So is it when it is not necessary to compel performance? Is it when any acts are necessary to be performed? Or is it to prevent the breach of an obligation? And for that reason, it is necessary to have certain acts being taken care of. And we think C is correct, and that is right. So in order to prevent the breach of an obligation, the court makes sure that certain actions are undertaken. As a general rule, the courts cannot specifically perform the contract in piecemeal, but it must be performed at all, exception being in case where the contract is divisible, parts of which are in themselves distinct whole, which we have dealt with this part of the question in earlier questions of this quiz. This was held in which case? Which case held this essence of the section that we discussed. Was it Mahmood Ali versus Yawar Beg? Was it Merchant Trading Co. versus Bomber? Was it Rutherford versus Acton Adams? Or none of the above? I think Shaktija has answered. Have you? I'll begin the timer now. Prachi thinks it's none of the above, but it was indeed B, Merchant Trading Co. versus Bomber. That is the case in which this was highlighted. Section 13 of the SRA confers certain rights on whom of the following: the seller of immovable properties, the purchaser of immovable properties, the purchaser of movable properties, or all of the above. Section 13. Who has been given rights under Section 13? The purchaser, yes. Not the seller, Shaktija, the purchaser of immovable property. That is your option B, I believe. Section 13 of SRA has no application when the transfer has been effected in respect of a property A, in which vendor has no title or has an imperfect title, B, in which a vendor has title, C, in which a vendor has imperfect title, or none of the above. So where does Section 13 have no application? In which of these properties? Okay, Prachi thinks it is in none of the above. That means, Prachi, the section has application in all of these. Okay, you have corrected your answer. So it has no application where the vendor himself has title. And more guesses coming in. Shaktija thinks it's option C. And that is correct. If the vendor has subsequently to the contract acquired any interest, the purchaser or lessee may compel him to make good the contract out of such interest. Section 13A provides for this. So acquiring of the vendor, the title acquiring of the vendor has a certain effect here. The readiness and willingness of a party seeking specific performance needs to be of which of the following nature: must be averred and proved. We dealt with part of this before again. Must be proved only. Must be dispelled by the defendant through cogent evidence, or all of the following. So the readiness and willingness of a party seeking specific performance. How does it need to be presented before the court? It must be averred and proved. It must only be proved. It must be dispelled by the defendant through cogent evidence. Or is it all of the above? Anya thinks must be proved suffices. Rika also, Prachi also. And that is correct. We need it to be proved in court. And it was also held in the case of revision case of Govinda Chandra Ghosh versus and others. Again, specific performance of a contract cannot be enforced in favor of a person who has obtained substitute performance of contract under Section 20, who has become capable of performing the contract instead. So he can now, of course, perform the contract and does not need specific performance, who does not fail to prove that he has performed the essential terms of the contract, or is it all of the above? Tanya, and it's only the last question. So, where can it not be enforced? Tanya thinks a person who has become now capable of performing the contract. Oh, all of the above. Okay, Pritika also thinks all of the above. And the correct, we did deal with it before. If a person has obtained substituted performance under Section 20, he does not need specific performance. Now, we dealt with it before, guys. So that is why he is barred from seeking specific performance. No injunction shall be granted by a court in a suit under SRA 1963 involving a contract relating to private project work, contract of delivery of goods of a very old project, or an infrastructure project. A very easy question to answer. No injunction shall be granted by a court in a suit under SRA involving which of the following contracts? Yes, again, brainchild of the 2018 amendment. The infrastructure project, electric projects, infrastructure projects. Provision for who may obtain specific performance is given in which section deals with who may obtain specific performance. So who can be at the receiving end of specific performance? Section 14, 14A, 15, or 16? Shaktija, did you answer 14A? To whom may obtain specific performance? The correct answer is section 15. 15, not 14A. 14A was added due to amendment that we discussed before. Now, for construction of public hospital, suit for specific performance can be filed. Suit for specific performance cannot be filed. Suit for mandatory injunction can be filed, or none of the above. Now, this is again in light of 2018 amendment for the construction of specific performance of public hospitals. What is the status of specific performance? Can it be filed? Can it not be filed? Can you file a mandatory injunction instead? Again, it cannot be filed because they have special grants for infrastructure projects, electricity projects. They take preference, and specific performance suits are not fileable there. Okay, now we just need to pay a little bit of attention here. The vendee in a case, who is now a defendant, has paid rupees 1,000 as earnest money and then 24,000 after 7 days out of sale price. Now the vendee is still having a balance, but he does not pay the balance by the agreed date. But still, the whole amount is 25,000. The first 1,000 plus the 24,000 later, it's 25,000. If the vendor is not paying the remainder of the balance by the agreed date, the entire thing, the entire 25,000 is deemed to be forfeited. That is in the agreement. He is now failing to pay the balance amount. Okay? He has failed to pay the balance amount. In this case, which amount is liable to be forfeited as his earnest money? Is it 1,000? His 24th? So is it his first amount, the second amount he paid, a combination of the first and second amount he paid, or is it none of it? What can be forfeited as earnest money in this case? Aditya thinks it's 1,000. What about the rest of us? Is it 1,000, 24,000, or is it 1 plus 24, 25,000, or none of the above? Prachi thinks no amount should be forfeited, and it is 1,000 only, the amount that he paid as earnest money. That will be forfeited here. A suit by vendee for specific performance of contract to sell an agricultural land with condition of the vendor obtaining collector's permission cannot be decreed because the agreement basically is void. Cannot be decreed as the agreement is voidable at the option of the vendor. Can be decreed, but execution is subject to obtaining the collector's permission. Can be decreed, but because the agreement is voidable at the option of vendee. So a suit by a vendee for specific performance of a contract to sell an agricultural land with condition that the vendor obtains the collector's permission. Now, what happens to the suit here? Let's go through the question, clearly reading it, clearly reading what the stipulations are and what the suit is. Have we read it? So can the suit be decreed or not decreed? If it can be decreed, why? If it cannot be decreed, why? All right, Prachi thinks D. It can be decreed, but the execution will be subject to obtaining the collector's permission. We have to bear in mind the basic stipulations under the agreement. It was not void, it was not wrong, but we have to honor the stipulations under the agreement. So the suit happens, it can be decreed, but the stipulation remains. Two daughters and their parents agree to sell an immovable property jointly owned with a minor daughter to P with permission of court. Okay. The court rejected permission for sale of minor's share. P sued for specific performance of agreement to the extent of her parents and the major daughter. What happens to the specific performance here? Is it liable to be refused? Can it be allowed only to the extent of the share of the parents and not of the minor? Can it be allowed to the extent of the share of the two daughters who are there? Or can it be allowed to the extent of the share of the two daughters as well as the parents? Okay, so as it appears, there are three daughters, two major daughters, one minor daughter, and there are parents, of course. So, what happens to the specific performance here? P is suing with respect to the extent of parents and major daughter. Okay, allowed to the extent of share of two daughters and parents. So, two major daughters share allowed, parents share allowed. That's what we think here. But not the minors, and that is correct. A person entitled to the possession of specific movable property may recover it in the manner provided by TPA, sale of goods, CRPC, CPC. Specific movable property. Again, we dealt with it before. This should be easy to answer. Specific movable property and CPC deals with it. The recovery happens under CPC. Specific relief can be granted only for enforcing individual civil rights, enforcing both civil rights and penal laws, neither civil rights and or penal laws for specific performance of contract only. And that is right. We dealt with this before. This is for enforcing civil rights, individual civil rights. Where there is a single indivisible contract to convey land to several persons, some of them only cannot seek specific performance if the others don't want it. So you cannot sever specific performance in a single from a single object. If there is specific performance of a single contract, which is indivisible, the specific performance cannot happen for some of the people. What was this held in? Which case was this held in? Was this held in Munawar Hussain versus Zakir Hussain? Was it held in Mukesh Kumar versus Colonel Harbans Swaraj? Was it held in Haridas Sood versus Narendra Roy? Was it the case of Shyamlal versus Bhanwarilal? So if the contract itself is indivisible, the specific performance cannot be done for half of the people and not done for the remainder. That is Mukesh Kumar versus Colonel Harbans, in which this was highlighted. That is the specific case. The explanation provided under Section 16 of SRA is an explanation to which of the following? What specifically in Section 16 does it explain? Does it explain Clause 1, Clause A, Clause B, or Clause C? Or is it applicable on any of them or all of them? Explanation to Section 16. So it is to 16C. When we look at 16, Section 16, the explanation appended is for 16, subsection 16, Clause C. Which committee was constituted for the purpose of making suggestions for amending the SRA 1963? What is the name of the committee that was started? Is it the expert committee? Is it the legal experts committee? Is it the Manohar committee or the Malimat committee? So what amended the SRA 1963? Which committee was tasked with this? The recommendations of amendment. Malimat or okay. Manohar, Malimat, expert committee, legal expert committee. The name of the committee was expert committee only. Amending the SRA provisions of 1963. Expert committee, let's remember now. So the expert committee deliberated and submitted a report containing its recommendations to the Ministry of Law and Justice on which of the following dates. Now this is what has led to the 18th Amendment. 25th May 2017, was it 30th July 2015, 20th June 2016, or 29th February 2018. So when was the submission of reports done? Because of the watershed moment that the 2018 amendment was, these details become important. It was done on May 26, 2016, and then 2 years later it was enforced, which is why it then became the 2018 amendment. The recommendations to include sections 22A and B along with the explanations of these by the expert committee has been included in which amendment has been included in the Amendment Act or not. So the 2018 Amendment Act, the expert committee also recommended that sections 22 has A and B. We just saw A and B. There can be, along with the explanations, explanations can be for specific clauses of sections. So the recommendation was that section 22 A and B, along with explanations that erstwhile were, be included in the amended act. Was this allowed, or was this not allowed, or is it undetermined? Let's begin the timer. 20AB and so these have not been followed, right? So presently it only has 22. There are no provisions in the amended act relating to the provisions of 22 of the unamended act. So the erstwhile, um, how many members were the part of the expert committee? 3, 4, 5, or 6? How many members formed the expert committee that led to the 2018 contributions of the SRA? There were 6 total members in the expert committee. Who among the following was or were members of the expert committee? Was it Nilema Babde? Was it Dr. Mukulita? Was it both 1 and 2? Or were none of the above members of the expert committee? Divya thinks it was both, and that is correct. Both formed members of the expert committee. And now, when did it submit its? Who did it submit its report to? It did it to the Union Law and Justice Minister, but who was the serving Union Law and Justice Minister then? Was it D.V. Sadanand Gowda? Was it Ravi Shankar Prasad? Was it Kiran Rijiju? Or was it Lal Krishna Advani? These become important from the perspective of legal GK as well. That is also tested in DJS. So at that time, Sadanand Gowda was serving as the Law and Justice Minister at the Union. Now again, the presidential assent of the Amendment Act, when did it happen? I think we have seen this before, so let's receive quick guesses. September 17th, 5th June, 1st August, or 27 December. First August. Liquidation of damages do not form a bar to specific performance provided under which section? So liquidation of damages not barring specific performance. Which section provides for it? Section 21, section 22, 23, or some other section, and thus none of the above. Liquidation of damages not barring substituted specific performance. Pritika Prachi, don't think it's option C, and that is correct, section 23. A right which a party to a transaction sometimes has to have the transaction set aside and be resorted to his former position is called what? So you want to have the transaction set aside and you want to go back to the initial position. Is it called the right to be rectified, the right of rescission, the right of restoration, or none of the above? Again, a question we must know the answer to. That is right. It is rescission. It allows the party to rescind the contract, first of all, and that is how you return to the position where you began from. Not rectification, it is rescission. You rescind the contract itself. In cases where monetary compensation is insufficient to provide appropriate relief for the invasion or harm incurred, the remedy is available under which section? So, in the event that monetary compensation does not suffice, what remedy is given under which section? Is it section 38.1 that specifies about it, 38.2, 38.3b, or 38.3c? So if you've suffered harm or there is an invasion and monetary compensation is insufficient, where is the further remedy provided? And it is 38.3b, not just 38.1. 38.3b is where further remedies. Recovering possession of property is dealt with in chapter 1, 2, 3, or 4 of SRA. Prachi thinks it's 4, I think. It is in chapter 1. Recovering possession of property. This is in the very first chapter of SRA. A person who has been forcibly removed from the property has the option to file a lawsuit against the individual who physically carried out the eviction, the person who authorized the eviction, both A and B, or none of the above. So, a person who has been forcibly removed, dispossessed, and then forcibly removed, of course, from their property, who can he file a lawsuit against? The person who carried him out, the person who was behind it authorizing the eviction, both, or none of them. So, Prachi thinks both can be at the receiving end of the suit, and that is correct. So, the actual ejector and the person who made the call for the eviction to happen. The review of any order or decree is not permitted under which section of SRA? Section 5, Section 6, Section 7, or Section 8? Section 6 is correct. Which section of the Specific Relief Act has been revoked? Is it sections 41 and 42, 43, sections 43 and 44, or is it the very last section, section 44? Shaktija thinks it's 43 and 44 both, and that is correct. Sections 43 and 44 have been revoked. Chapter 2 deals with which of the following? Recovering possession of property, or specific performance of contracts, or injunctions, or is it none of the above? Chapter 2 of the Act. Come on, guys. Specific performance of contracts. It cannot be A because we just uncovered that it was under Chapter 1. Under Section 36, how many types of injunctions are enlisted? 1 injunction, 2, 3, or 4? 36 of SRA provides how many injunctions? Two types of injunctions, that is correct. In which section is the provision for damages as an alternative or addition to injunction provided? Section 37, Section 38, Section 39, or Section number 40? Damages as an alternative or addition to injunctions. Okay, we are getting a few answers for B, a few for D. The correct answer is D. It is Section 40 that enlists damages in lieu of or in addition to injunction provided. Who is eligible to seek rectification of an instrument? A plaintiff to the case, a defendant, a third party, or can it be either plaintiff or defendant? It is either party or his representative. So either party means plaintiff or defendant, or the representatives also qualify under plaintiff or defendant. This is Section 26 that speaks about it. Under Section 20C of SRA, for disposal of a suit, the maximum period provided is 20C limits the maximum period of Disposal of suit at 6 months, 12 months, 18 months, or 24 months. 20C. It is 12 months. Chapter 4 of the SRA deals with rectification of instruments, rescission of contracts, declaratory decrees, or none of the above. Rescission of contracts. That is great going. That was your very last question, guys. There were a few errors along the way, but we caught them. And I'll have Gagan informed, and those will be corrected, don't worry. And as always, please take your mocks. Just make sure if you've skipped it, you're attempting that well ahead of midnight tonight. Or if you cannot attempt it today, it's best if you attempt it today only. If you, for some reason, cannot, it will be made live again after 2. There was a glitch in the paper today, unfortunately, but that has been resolved, and you can take on to attempting the paper and it will work perfectly. So make sure you attempt and let me know of your scores or any difficulties that you might face. So hopefully this was helpful for all of us here, and have a great evening going forward, and make sure you turn up for your next paper tomorrow. And also the marathon sessions are incredibly important, as well as the quizzes that we conduct right here. So don't shy away from any of those resources, and take care. Just let me know if you face any issues or login issues or questions that you don't understand or questions you have errors in or confusions in. Also, keep me updated on your scores. You have my contact on the WhatsApp group provided. So, take care, guys, and have a good evening ahead.